cases on the oral argument docket, and we will be taking them in the order they are listed on the docket. If you are the appellant and wish to reserve up to 5 minutes for the rebuttal time, let me know, and then I will keep track of time and let you know when you get to that point of the argument. And if you wish to continue to reserve that time, that's certainly fine. If you wish to go forward and waive it, pull it apart, that's fine also. So with that, the first case is Gramatis versus State.
Good morning, Your Honors.
Good morning.
May it please the court, counsel. Your Honors, Thomas Graydick for Gramatis in this case. And we're here today because within 2 minutes, 4 times the prosecutor referred to Mr. Gramatis's either statement or invoking his rights to the police officer. So they start out, it was very quick in the trial. This was right after COVID. So the officer says, I spoke to the loss prevention officer and also the defendant. Then the prosecutor followed up and said, did you speak to the defendant and the loss prevention officer while investigating this? Then again asked, and after speaking with the defendant and loss prevention officer, did you determine if the theft occurred? Again, the officer said yes. And then immediately followed that up with, did you make an arrest? And then followed it up again with, did this investigation warrant speaking with more witnesses than you spoke with that day? Again, referring back to the statement Mr. Gramatis had given or invoked. And then even went beyond that and bolstered it by going, did you require more proof? The only inference you can make from that is either Mr. Gramatis confessed or he invoked his rights. And so that opened the door. And so when I got up and I said, well, what did he say in essence? I said, Mr. Gramatis told you he was willing to pay, is what's in the transcript, and then the state objected. When the state objected, the judge sustained it. Then he said, no, I'm going to overrule that. Then he said, no, I'm going to the bench. And then unfortunately with the transcript, because we were wearing masks at the time, it's why it's all inaudible, where I explained the theory of defense in the case was that Mr. Gramatis had left his wallet in his car. And what unfortunately the transcript doesn't show because of the inaudibility of when we were at the bench is that as Mr. Gramatis was leaving on video, there's a clerk who was not called as a witness. And Mr. Gramatis stops and he points and he goes, and the clerk says, nods and gives him permission. Because what Mr. Gramatis was doing was saying, I left my wallet in the car. I'm going to go get the wallet and come back. That is the statement he made to the officer. He said, I forgot my wallet. I'll pay you for it. And so after the state did that, I got up and I said, well, they've opened the door, obviously, as to what he said. Otherwise, it's either comment on his right to remain silent or he didn't invoke anything. And the state's the one who initiated this. They're the ones who brought it out and said, hey, what did he say? Did you talk to him? So at that point, when I asked, by being stopped, in order to clarify and explain this is what happened to counter the inferences that the prosecutor brought up, was the error in this case. And it's either an error because it's a comment on his right to remain silent, or it's an error because they opened up the door and didn't let me speak.
Did you object?
I did not object to
The officer's testimony.
Correct. And as I told, I've been perfectly upfront with that strategy. I did that on purpose. If you want to open the door, I knew I could not get his statement and that I'd have to put him on the stand. And Mr. Gramatis is older. He had a health incident that morning, but that was strategy. I'm sure, go ahead, start talking about a statement because I want to get into it. And so I know that's one of the points that the appellant makes is that I didn't object and waived it. And when you look at Hoggins, the Florida Supreme Court case, it says we're doing a harmless error analysis. So even if you didn't object, we got to look and see. But that's where the sword and shield comes from. They wanted, the prosecutor wanted to come in, ask that question and say, did you talk to him and, get into it. And then they want to shield themselves, which is exactly what happened.
And at the end of when you had your opportunity to cross the officer, right? You asked him a few questions and he agreed with you with the proposition and cross-examination that he saw Gramatis outside talking to the clerk and gesturing towards the car. And he also agreed that that would be an important bit of information if what Grammatis was asking was to get his wallet, right? So the jury heard all that.
But they didn't hear, the problem is that that's me coming up with a theory as a lawyer down the road. But it doesn't cover up the fact that the only implication you have is either he confessed, because the officer said I talked to him and I arrested him.
Well, that's not exactly what the officer said, was it? The officer said, after speaking with the defendant and loss prevention officer and reviewing the video, that I made an arrest. So in other words, the officer testified, after conducting my investigation, I arrested him.
Right, 4 times, that's the one, and then he says, and after speaking with the witness defendant, did you determine that theft occurred? And so the problem is that, what did Mr. Grammatis say? Did he invoke? And anytime it's a comment on the right to remain silent,
I think that's what I'm having a hard time with, because I don't see how it's a comment on his right to remain silent. Or
because, I'm sorry, Rob,
or rather how it gives the implication that he confessed. If the officer says repeatedly, I did all of these things and then arrested him.
because it's all at one very quickly, and that's not distinguished in here. What he said is that that I spoke to him and I made the arrest based on speaking to him. Yeah, he has the other evidence.
And where exactly in the record does he say, based on what he said, I arrested him?
On page 199, line 11, where he says, and after speaking, the prosecutor asks, and after speaking with the defendant in LPO, did you
And
determine?
reviewing the video, did you then determine whether or not that had occurred?
Correct.
Yes, I did. Did you make an arrest after completing your investigation? Yes, I did. So
Correct.
it is not merely based on what the defendant told me. It's, I spoke with the defendant, I talked to the loss prevention officer, and I watched the video.
Right,
So how does that necessarily give rise to the implication that the defendant confessed?
what else could it be is the problem, because you're the one planning it as the prosecutor, you're planning that in the jury's mind, that I spoke to him. And so what he said or didn't say is extremely important.
Why couldn't he have just said, I was asking to go get my wallet?
I'm sorry?
Why couldn't he just say what your theory was? Couldn't he have just said that he told the clerk he was gonna go get his wallet?
That's what I tried to do, and that's when the state objected. That's what I was trying to
But that's another
clarify.
end. The point is, that's another option besides confessing
Is explain, right.
or
and
invoking
that's-
his rights.
That's why I needed, right, there's 2 options. He either invoked or, he either confessed. This is the way the jury hears it, because I didn't get to be able to put that before the jury. That's the whole point of it, is to limit and explain this is what happened, to have that opportunity, because it's misleading. It's to a jury. The thing is, the prosecutor should never have brought it up and said, I spoke to him and then made the arrest. There was no need to get into it, and that's why I didn't object, because I wanted to get his statement in to clarify what exactly Mr. Grammatis said, because that was the theory of defense, that he forgot his wallet and he was coming in to pay. And so when the officer says, well, I spoke to him and I made an arrest, and that's exactly the question I wanted to ask. He told you he forgot his wallet. To explain away, wait, you spoke to Mr. Grammatis, so he must have confessed. This must be new theory that the lawyer came up with, when it's not. From the beginning, and it's on the video where he goes, I forgot my wallet.
Well, we don't know that's what he said, do
Pardon?
we? We don't know that's what he said.
Well, and that's part, it was proper.
You asked the question and the officer pushed back against the question and said, well, if that's what he said. So at what point in this transcript did you proffer to the court testimony, either from the officer or from your client or otherwise, that this in fact is what he said?
Unfortunately, it was at the sidebar that's inaudible.
So doesn't that create a problem for us? Because you're asking us to make the assumption that this in fact is the theory of the defense that could have been established, but we really don't know what your client said. And we don't have the officer testifying, yeah, he told me he was going to get the wallet. In fact, your question was, he might have been pointing to merchandise that was outside, and maybe he was going to look at that, or maybe he was going to his car to get his wallet, but we don't know that.
I understand, and that's part of the problem is the proffer, because it's coming out of
It
COVID.
doesn't help us that it's sidebar. And
No, it doesn't, and, sorry,
No,
Rob,
and it could have been put on record, but it wasn't.
right, and unfortunately, when you're doing a trial and you're up at the bench where the microphone is, you're assuming it's picking everything up, otherwise I would have offered it. But we did at the bench, and unfortunately, I don't know why it didn't pick up. But you can see clearly it's the inaudible part, but you brought up you're bringing up my argument for me, where you're going, you know, you didn't bring this up or have the officer, because that would have made a difference, and that's what I'm saying, it made a difference in this case, a statement to the officer saying, you know, I forgot, and the video backed that up. And when I'm arguing to the jury, I'm gonna go, look, it could have been something outside, it could have been the wallet, because at that point, I don't have a statement in. And I didn't invite it, I didn't say, you know, the state went and asked him and said, what did he say? And then they even tried to bolster it, going, did you require any more proof? Again, that goes, you know, once the horse leaves the barn, you shut the door, it's out there and I gotta deal with it. And that's the problem is, unfortunately, I did proffer it. You know, I was the only one who was there in the courtroom today, but it just for whatever reason with coming out of COVID, I think it was the second trial in jail, COVID second or third. I don't know why I didn't pick up, but we were at the bench where I would be standing right there where you know, where your sign is, Judge. And for whatever reason, it didn't pick it up. But the only, if you're a jury and they plan it in your head, they're going, the prosecutor saying, you spoke to him, what did he say? You know, or you spoke to him, they're like, either he invoked or he confessed, because immediately after you made the arrest after speaking to him. This is a very quick investigation, very quick, came out, boom, 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 and the arrest is made. It's a very one short out one thing. And when the jury's sitting there going, well, they must have confessed, the cop arrested him. You know, there's no other further explanation as to the mistake of leaving the wallet in there, and I can't get into it because I was objected to. And the door's open. I mean, you asked 4 times, going, did you speak to him? And then I just get up there and go, what did he say? And then they want to go, well, no, now you can't do that, which is the same thing that happened in, I think it was Brunson, where you can't use it as a sword and a shield. We're going to have it to show you did a complete investigation. We're going to show that you did everything you were supposed to do. We're going to show that you spoke to Mr. Grammatis and he either said, I'm guilty because I want a lawyer, or he confessed because you arrested him. He didn't do anything after to say, well, let me go talk to the clerk, because he didn't talk to the clerk to see, did you have a conversation about forgetting your wallet? And that witness wasn't there. I think he was lost and moved away. But that's the problem, is that I should be able to limit or clarify what exactly happened between the officer and Mr. Grammatis, because that's what's hanging in the juror's mind is, well, he must have confessed. You arrested him, or he must have invoked. Because if he had made that statement that I forgot my wallet, surely you would have talked to the store clerk on the video that you saw, where there's communication between the two, and the officer did not do that. So if the officer didn't do that, there's only one conclusion is made, is he invoked or he confessed? And that's where the problem is. And, you know, we make mistakes as prosecutors, as young lawyers, but that's what he did. And yeah, I was like, that was my strategy. When you say, why didn't you object? It's because I wanted his statement in, I needed it in to show he just left his wallet. And that was part of the problem, was putting him on the stand, he was sick and doesn't communicate well. But when you're on the video and you tell the officer, and then he didn't do a full investigation, because you have the video where they're communicating, going, and then the clerk nods and says, go ahead. Why didn't you talk to the clerk? He's a key.
You argue that to the jury. Did you?
I did, but if I
Find
had,
out.
yeah, but if I had a statement going, I forgot, that makes it all the more important. You know, it was heated in the jury room. It took them an hour to make a verdict. There's yelling and screaming back there. David told me, but it's one where it makes a huge difference, because why didn't the officer talk to that clerk?
Counsel, did you want to reserve any time for rebuttal?
If I could, 5 minutes is fine.
You're almost at 5 minutes. You have 1 minute till you get there.
Okay, but yeah, that's the problem is, You speak to him, speak to him, speak to him. Why didn't you speak to the clerk? You said you watched the video. You clearly see the communication between the two, but you don't talk to that person. Well, the reason I don't talk to him is Mr. Gramatis confessed. I didn't talk to him because Mr. Gramatis invoked his right to counsel, so he must be guilty, because unfortunately, that's what jurors think. And so the prosecutor opened the door, and then they prevented me from getting into to clarify what exactly was said, what that communication was, because otherwise I walk in and the jury's like, yeah, you hired a lawyer after the fact, and he came up with this theory and defense that you never told the officer that previously. This is just the lawyer making this up to give you a defense to the
Then you're at the
charge.
5-minute part.
Thank you.
May it please the court, my name is Lindsay Sims Bowmansteel of the Office of the Attorney General, and we represent the appellee in this matter, the state of Florida. This court's review on appeal, and one thing that has been appealed here or addressed in the initial brief, is whether the trial court properly denied the motion for new trial. So the review was limited to whether the trial court abused its discretion in denying the motion for new trial. That is, that this court should reverse only if it finds that no reasonable jurist would have decided as the trial court did. The trial court did a very detailed analysis for a county court on a retail theft charge of its basis for denying the motion for new trial. And first I want to point out one of the things that was in the motion and gets argued at the motion hearing is, and is mentioned as well in the order denying, is that there was no testimony in this case that Miranda was read, that the appellant confessed or invoked. The only testimony was the steps of the officer's investigation, which included speaking to appellant. And opposing counsel makes the argument that there's really only two inferences that can be made from that statement that that the officer talked to appellant. But there's also testimony there that he talked to loss prevention officer Hughes and also viewed the video. And presentation matters in this jury trial. The jury has just heard from Hughes and has just also seen the video. So they're aware that the video shows the appellant leaving the store with the merchandise.
But what if he had been permitted to say, he told me that he had told the clerk that that he was going to get his wallet. And so wouldn't the reasonable juror think, okay, well then if that is in fact what he said, why didn't the officer go talk to the clerk? So wouldn't that have been a reasonable question in the jury's mind?
It may have been a reasonable question in the jury's mind, but it wouldn't have, I mean, he didn't go get his wallet, right? He removed all the merchandise from the store, or he was doing that at the time that he was stopped by loss prevention officer Hughes. So while it would have been an explanation, perhaps, it wouldn't have been a complete defense to the theft of the merchandise from the Home Depot, which was captured on the video. It was, one of the things that the trial court addresses too is whether or not the door was opened to that question. And the trial court noted that that would have been self-serving hearsay, which would have been inadmissible at the trial. Now, this is a very different case from Brunson, relied upon by appellant, in which there was a video of a traffic stop and the question gets admitted, do you have any criminal history? But we don't get to hear the defendant's answer. And Brunson later, when he goes to testify to say, and wants to say, well, I don't have any criminal history. the state moves to eliminate that out. Well, that's sort of the problematic gamesmanship that appellant noted in his brief and is noted by the appellate court in Brunson. Very different here from where we don't really have a comment on any statements that the appellant made. All we have is information about the investigation. And although opposing counsel says there was an attempt to proffer the statements at the bench, we really don't have that in our appellate record for you to review. What we do have is the trial court's carefully reasoned order denying the motion for new trial, which was substantive and the state would submit accurate. If there are no further questions as to any other issues, we would rely on our brief and the state would ask you to affirm. Thank you.
Thank you. Counsel?
May it please court, again, we're on the video, which is in the evidence. I know you don't get to see it. As soon as he went out of the store, loss prevention officer went and stopped him. So I think he was 3 feet outside the store when he was stopped and brought back in. But what Judge Gray did not have a transcript of the hearing, and he didn't address the issues about the proffer either. He went over that, but this case is directly on point with Brunson. It was, the prosecutor went out and got into an area they shouldn't have, and I'm entitled to clarify that so that, because what's planted in the juror's mind is it's a confession or it's anything, you know, fairly susceptible or comment on the silence. It's one or the other. But to get up as soon as I was starting to ask, that's what the prosecutor did. They used it as a shield and said it's the same thing as Brunson, where in Brunson they played the video, didn't object to it, and they asked the question, did you have a prior arrest? He doesn't answer. So they get up there and they're going to go, all right, did you have, you know, prior arrest? And they want to object to it and use it as a shield for yeah, testimony I wasn't able to get into, but luckily they opened the door. That's what I wanted. That's why I didn't object. And that's why they kept going into it. And the first question I asked was, you know, did he told you he paid for it. And then I can follow up because he had his wallet and forgot it. That's it. And I couldn't get into that. It was proffered up there. It's clear that's what I was getting into. And it's clear that question alone where the state says, no, you can't do it, that we object to it, is where the error is. Because it's fairly susceptible, as I said, anything that, and that's one of the things Judge Gray in his ruling didn't address is, you know, well, it wasn't Miranda. The courts in the cases clearly say it doesn't have to be Miranda. If it's all contemporaneous with the arrest, you don't need Miranda, you don't need pointed questions. It's how do you interpret it? And as a jury, you're sitting there going, they didn't talk to the clerk. The guy must have confessed. Because the state hasn't come up with, all through the briefs, all through this, one reasonable explanation of what he said. One reasonable
The
explanation.
officer didn't give any testimony as to what your client said to him, right?
Right, exactly, and that's the problem. But
And the Brunson case and other cases are generally where some evidence is in, but it's not the complete evidence as to what was said or what was observed. So isn't that distinguishable here where the officer says, I spoke with him, but there's no evidence as to the substance of the discussion?
No, because you get the other cases, Thompson, such where they go, I spoke to him and then I made arrest. Did he give you a reason at that time? No, it's the same thing. Thompson's right on point. He said, did he give you a reason for his behavior? And he says, no, and they reversed. Second DC, I believe that was.
So that's because they got into the substance of the discussion.
That was the only thing they said though, right?
But that was substance.
Correct.
We don't have any substance of any discussion here.
No, but what we have is that I'm not allowed to, I tried to get into it. I was denied, but
Your client could have testified, there are reasons he chose not to, but he could have gotten his testimony in that way, correct?
he could have, yes. And then the only issue is it invented later. And that door's open, but it goes to the impression that's planted in the jury's head. When you say, I spoke to him, but I didn't speak to the clerk. Because that conversation, which wasn't recorded on the audio, you're planting in a juror's mind going, hey, he either confessed or he invoked. What I
Or the
think-
officer didn't conduct a sufficient investigation.
In part, he did if we would have had the statement come in, and then I really would have, it would have bolstered my defense of, he didn't do a complete investigation. He was given this information by Mr. Grammatis. He spoke to Mr. Grammatis, and then he refused to follow up on it. And so all the cases is what does the jury think? What is planted in their minds? And the only thing planted in it is either confessed or you invoked, which was it? What other explanation could a jury have thought, and no one has ever put one forth, of what Mr. Grammatis would have said? That they didn't talk to the clerk, that he arrested him immediately. That's one that I've been waiting for the prosecutor and why I put in my, the reply brief. There's been no explanation any other reasonable explanation as to what Mr. Grammatis said to that officer.
And you are about done, so go ahead and conclude, please.
Judge, it's basically what I said all the way through. If they used it as a sword, shouldn't have got into it, and then once they did, they stopped me from clarifying that, which I'm entitled to do. The door was open.
Very good. Thank you both very
Thank
much.
you.
The next